defamation that says in certain cases damage can be presumed, which means the plaintiff isn't going to have to prove it. In what cases? Now, divide all defamation into libel and slander. And let's start with slander. The general rule about slander is that damage must be proved. However, there are 4 exceptions to that rule. If the slander accuses the plaintiff of being an unchaste woman, or accuses the plaintiff of having a loathsome disease, or accuses the plaintiff of a crime of moral turpitude, an immoral crime. Is there any other kind of crime? Well, maybe speeding is not an immoral crime. Or if the slander accuses the plaintiff of something that is inconsistent with the plaintiff's occupation, then traditionally the plaintiff did not have to prove damage. Damage could be presumed. Now remember, the Supreme Court says, you can't presume damage unless you prove actual malice. But if you do prove actual malice, those traditional rules might still apply. In those 4 special cases, damage might be presumed, but what we're going to do is treat those 4 exceptional slander cases as if they were libel. And I'll explain in a moment why I'm putting it that way, but I do want to tell you that those 4 exceptions are referred to as slander per se. Slander per se is a slander that accuses the plaintiff of being an unchaste woman, or of having a loathsome disease, or of being guilty of an immoral crime, or of something inconsistent with the plaintiff's occupation. Slander per se. Treat slander per se as libel. Now, the general rule for libel is if the statement is libelous on its face. Remember, we talked before about the difference between defamation on its face and defamation by innuendo? It's defamatory on its face if the statement itself contains all you need to know to associate shame or disgrace with the plaintiff. If the statement is libel on its face, damage can be presumed. Remember, that's subject to the Supreme Court's requirement of actual malice. If the statement is libel by innuendo, then damage cannot be presumed. Damage has to be proven. So we're going to treat slander per se as libel, which means if it's slanderous on its face, damage can be presumed. But if it's slanderous by innuendo, damage will have to be proven. If a statement is libelous on its face, damage can be presumed. If a statement is libelous by innuendo, damage must be proven. There are 3 torts related to defamation that we also should review. One is an invasion of privacy known as false light. It's like defamation in every way except the statement made about the plaintiff doesn't have to carry an element of shame or disgrace with it. It only has to be embarrassing. If people go around saying, "Did you hear about poor Fins? He died," that wouldn't be defamatory because there's no shame in being dead. But it might embarrass me. It might cause me to lose some business. It might cause me to lose some money. And so it might be a false light privacy invasion. Everything else about it is the same as defamation, except that damages always have to be proven in false light privacy cases. Another tort that's very similar to defamation is injurious falsehood. Injurious falsehood is business defamation. It's just like defamation in every way, except that it's a statement about the plaintiff's business interest rather than about the plaintiff personally. The only differences between injurious falsehood and defamation: there's never a presumption of damages in injurious falsehood cases, and some jurisdictions require proof of special damages. That means prove how much you lost in dollars and cents in order to recover in an injurious falsehood case. So we've got libel, we've got slander, and then we've got 2 torts that are like defamation called false light privacy and injurious falsehood. I mentioned that false light privacy is an invasion of privacy. There are 3 other invasions of privacy that are torts. They really have nothing to do with defamation, but because we talked about false light privacy, I think we're going to finish with these 3 invasions of privacy. The first is called misappropriation of personality or appropriation of identity. It's a tort that's committed by making an unauthorized use of the plaintiff's name or likeness or identity for a commercial purpose. Unauthorized use means the plaintiff did not give permission for that use of his or her name. Plaintiff's identity is anything that would allow the plaintiff to be recognized by a person, the reasonable person, the fictitious reasonable person who knows the plaintiff. And a commercial purpose is something that's likely to result in a profit to the defendant. Now, this privacy tort, appropriation of identity or misappropriation of identity, is really based on the philosophy that a person's identity is his property, and that if I use your identity to make me wealthier, I'm really taking your property for my purpose, and I should have to pay you whatever profit I get from that, and perhaps other damages also. Appropriation of identity is not available as a tort if the publication involved is newsworthy. There was a case recently about a newspaper that had run some stories about the football star Joe Montana. And then they took the photographs they had published in their newspaper about Joe Montana and they put them into a poster, which they sold for $5. And Joe Montana said he wanted a piece of that $5. They had no right to sell his picture without his permission. But the court said that the newspaper did have a right. The poster related to newsworthy events. I think it was Joe Montana's victories at the Super Bowl. And the court said the privilege to publish somebody's name in connection with a newsworthy event even applies to a profit-making publication. The next invasion of privacy is called intrusion, and it's committed by making a physical invasion of the plaintiff's private space in a way that would be offensive to the reasonable person. This is the tort I commit when I peek into your bedroom window. This is the tort I commit when I come right up to you and shove a camera in your face and snap your picture. Now, I may have a right to take your picture, but if I get too close to you and shove that camera right in your face, I may be committing a tort. In fact, there was a photographer named Ron Galella who used to do that to Jacqueline Kennedy Onassis every time he saw her. He'd run up to her and shove a camera in her face and take her picture. And finally, a court held that he was committing this tort against her. The final invasion of privacy is called public disclosure, and it's committed by publishing information, and in this case, publishing means circulating to the general public. Publishing information about the plaintiff which is private and which the reasonable person in the plaintiff's shoes would want to keep private. And once again, there is a privilege for publishing newsworthy information. That's why you see articles all the time about this actress or that actor entering the Betty Ford Clinic to get treatment for drug abuse. Let's take one hypo that'll illustrate all 4 of the privacy invasions. Paul Plaintiff, a movie actor, is sunbathing nude in his backyard. Dan Defendant climbs the fence around Paul Plaintiff's backyard and takes photographs of Paul in the nude without Paul's knowledge or permission, and then sells those photographs publicly for a profit. First of all, it's possible that Paul Plaintiff could succeed in a false light privacy action, because it may be that by selling the photographs of a nude Paul, Dan the defendant is making a false statement to the effect that Paul Plaintiff poses nude for these photographs. And that might be an embarrassing statement, and it might lead to liability for false light privacy. Of course, since Dan Defendant is making a profit by selling photographs of Paul Plaintiff without Paul's permission, he might be liable for appropriation of identity. Since he climbed the fence and peeked into Paul Plaintiff's private place to take these pictures, he might be liable for intrusion. And since he has shown the entire world or the general public what Paul Plaintiff's naked body looks like, and that's usually something that people retain as a private fact, he may be liable for public disclosure of a private fact. So all four of these privacy invasions may have been